I'm going to introduce her anyway. She's a graduate of St. Louis University School of Law. She was in private practice. She's a former United States Attorney, District of South Dakota. And in June of 1999, she was the first woman confirmed to serve as the United States District Court in the District of South Dakota. She served as Chief Judge from 2006 to 2012, and she's been a member of the 8th Circuit Judicial Conference's Planning Committee, a member of the Federal Judges Association Board, and a member of the Bankruptcy Committee for the Judicial Council. So with her presentation failed to preserve, so what? Please welcome Judge Karen Schreiber.
Thank you. When Judy called and asked if I'd speak on this topic, she said, "Have you had any of these issues come up in federal court?" And at the time, within that last month, right before she called, I had a party who was defending a motion for summary judgment argue that they were entitled to an adverse inference because electronic data had been destroyed. I had a discovery dispute dealing with electronic data. I had a case that was going to trial where they were seeking an adverse inference instruction because electronic data had been deleted. And finally, I had just finished a trial where somebody had taken a photo of a combine fire. They'd ended up selling their telephone that had the photo on it, didn't have the photo any longer because they traded their phone in, and the other side was arguing about that. So I told her, I've got a couple things.
Yeah.
So today I wanted to talk to you a little bit about, first of all, why are there sanctions for spoliation of evidence? And Wigmore on Evidence noted that it's long been recognized that a party's falsehood or other fraud in the preparation of a case, including the intentional destruction of evidence or the fabrication of evidence, is an indication of the consciousness that the case is either weak or lacks merit. So that's what the underlying theory is. It's kind of similar in a criminal case where somebody's knows they're under investigation and they take off and flee. It's evidence, that evidence of flight is evidence of consciousness of guilt. So this is kind of the civil component of that. In federal court, the first thing that I always have to look at is what law do I apply in a diversity case, and that's where most of these arise. Do I apply state law or federal law? And for many years in the 8th Circuit, the court didn't really address the issue. They'd always look at state law, look at federal law, and basically conclude that they reached the same conclusion applying either one. So for many years, I had to do the same thing. Look at what state law would find, look at what federal law would find. It usually was the same conclusion and apply that. But in 2012, the 8th Circuit finally answered the question and said that it's federal law that applies, whether it's a diversity case or a federal question case, I apply federal law. The next question is, when does the duty to disclose arise? In federal law, it's part of the initial disclosures under Rule 26. That's what makes the duty to disclose, first triggers it. So if you're a party, you have that duty, even though there hasn't been a discovery request served on you yet. You're supposed to provide the other side, the other party, with a copy or a description by category and location of all of the ESI that is either in the party's possession, their custody, or their control. Anything that may be used to support their claims or defenses. The only thing that doesn't need to be disclosed is if it's used only for impeachment purposes. The duty to disclose doesn't apply if the ESA is not readily accessible because of undue burden or cost. So there's a couple questions there. Is it readily accessible? Is there undue burden or cost? So first, I'd like to look at the issue of whether it's readily accessible. And something that's readily accessible is data that's stored in a readily usable format. So it doesn't need to be reconstructed, it doesn't need to be restored, or it doesn't need to be defragmented. And the court looks at the issue at the time the litigation is commenced. So what format is it in when the litigation is commenced? If you're going to claim that something's not accessible, you should be very specific with the other party and with the court. And remember that when you're claiming it's not accessible, or it's too expensive, or it's overly burdensome, it's your obligation as the objecting party to prove that to the court. One of the things that's most helpful if you're going to raise any of these claims or defenses is that you should hire an eDiscovery expert so that you can have someone give you an opinion of how much is involved, what format is it in, someone that can actually document what your defense would be. So when is the duty to preserve triggered? This is a question that frequently comes up in litigation. It's when a party reasonably should know that the evidence may be relevant to anticipated litigation. And there's no easy answer here. It's a really fact-intensive question. For the plaintiff, it's clearly when litigation is anticipated. It's not when the complaint is filed. It's when you start thinking about filing litigation. For the defendant, the very latest point is when the complaint is served on them. But it may be earlier than that. It could be when you get a litigation hold notice. It could be when the parties lawyer up. It could be when a big accident has happened and you know you're probably going to get sued. It's a very fact-intensive question, and it's a little more wishy-washy on the defendant's side. But on the plaintiff's side, it's clearly when you start anticipating litigation. Do not wait for a formal discovery request to come in, because the anticipation is long before that. So as a lawyer, you need to start talking to your client and making sure that they understand their duty to preserve ESI has started. So your duty as a lawyer, when litigation is reasonably anticipated, you need to tell your client to preserve all of the ESI. And you need to periodically remind them of this. I can't tell you the number of times that the lawyer will say, well, I told them right away. But then companies go through new employees. New employees don't know because they weren't there when the lawyer first told them. Especially in the IT area, those people need to know because they're the ones that know what the company has, what needs to be preserved, and how you would go about preserving it. So you need to talk to the key employees, not just the company head, but get down to the IT employees. You need to make sure that you're clear with employees about their responsibilities on how to preserve the electronic data. And for companies that have an automatic retention or destruction policy, you need to make sure that that is suspended. Especially once litigation has started, if they are still deleting data that might be relevant to this case just because that's their policy of automatically deleting after 30 or 90 days, that's not going to be good enough from the court's perspective. Once the litigation is anticipated, they have a duty to preserve and to suspend what their automatic detention or retention or destruction policies are. So when I'm looking at what's reasonable, it really depends on the facts of each situation. The court will look at what was done and what was not done by both you and your client. And I emphasize you because when I start getting into the part about sanctions, you'll understand that it's not just your client at risk, it's also you that sanctions can be imposed against. I'll look at the sophistication of the parties, whether they've been involved in a lot of litigation before. I'll look at what the efforts were that were made to preserve. I'll look at what seems proportional or reasonable under the circumstances, and what's consistent with current standards. And now I'm going to move into, if the ESI is not preserved, what theories are there to impose sanctions, and what sanctions are available. One of the theories, and there are many theories that sanctions can be awarded under. First one, Rule 26G. Rule 26G requires that every disclosure under Rule 26 and every discovery response has to be signed by the attorney of record. And it also includes a certification on there that the information provided is complete and accurate. So if the information ends up not being complete and accurate, sanctions can be imposed against either the party, their lawyer, or both. And part of the certification also includes a requirement that you have to conduct a reasonable inquiry into the disclosures. So before you sign your Rule 26 certifications, you need to make sure you've done a reasonable inquiry and that the information that's provided is complete and accurate. Another theory for recovering sanctions is under Rule 37B. And this is the rule that applies when the court's already issued an order to compel. For instance, to respond to an interrogatory or produce a document. And that document may include ESI, and the party then fails to respond. That failure to respond may result in the court imposing sanctions. And those sanctions would be against the party for violating the discovery order. The sanctions are pretty broad. It can include directing that certain facts have been established as true, prohibiting a party from supporting or opposing certain claims or defenses, prohibiting the introduction of certain evidence. The court could strike pleadings. The court could stay the proceedings, could dismiss the action, could enter a default judgment, could find a party in contempt of court, and/or it could award reasonable expenses. Another avenue for seeking sanctions is under Rule 37C. And this applies if a party doesn't make the required disclosures under Rule 26A, or if the party fails to supplement their disclosures. And the sanctions that can be imposed under 37C include everything I just went over under 37B. And in addition to that, it could prevent the party from using the evidence for the witness that wasn't provided. The court can inform the jury of the party's failure, and it can also award reasonable attorney's fees and expenses. Another grounds for seeking sanctions is under Rule 37D, and this is the rule that applies if a party failed to respond or object to a request for production of documents under Rule 34. And 37D sanctions include everything we already talked about on 37B, plus the payment of reasonable expenses by the party or its attorney or both. Another grounds that you can seek sanctions under is statute 28 U.S.C. section 1927. And this statute applies whenever an attorney unreasonably and vexatiously multiplies the proceedings in any case. So you can actually seek sanctions under this statute. Under this statute, the court can only impose sanctions against the attorney, not against the client. It's only against the attorney. And the award would be of any excess costs or attorney's fees that result from the offending attorney's conduct. And finally, the most common and the broadest authority that's used to seek sanctions is just the court's basic inherent authority. Courts have the authority and the ability to manage their affairs and to achieve the orderly and expeditious disposition of cases. Now, this principle has been recognized by the U.S. Supreme Court. and it provides for just a huge, broad range of sanctions that includes everything that I already previously mentioned. Plus, you could seek an adverse jury instruction. The court could find that you have a reduced burden of proof because of what happened. The court can either reduce or take away the number of jury challenges that the opposite side has, could limit closing arguments, could authorize supplemental discovery to the non-sanctioned party. It can grant additional access to computer systems. It could impose cost shifting for forensic review. It could bar further discovery by the non-sanctioned party, or could extend discovery deadlines. It can also dismiss a cause of action or the entire case. So it's a very broad range of things that the courts have authorized and have done. The standard in the Eighth Circuit for having sanctions imposed kind of depends on what sanctions are being imposed and what stage of the litigation the destruction of the evidence occurred in. If you're trying to seek something as severe as dismissing the entire action, the Eighth Circuit requires a showing of bad faith. If you're trying to get an adverse inference instruction, it depends on when the spoliation occurred. If it's before the litigation was anticipated, you have to make a showing of bad faith and that the evidence that was destroyed was relevant and that there was prejudice to the party. To show prejudice, it's kind of not a clear test, but generally you'd have to make a showing that that evidence would be helpful to you and it can't be replaced or reproduced in some other manner, and that it really harms you in some way. If the destruction happens after the litigation is anticipated, the Eighth Circuit's not clear on whether a bad faith showing is required. Some of the earlier cases indicate that it's not, that there's not a requirement of showing bad faith. Some of the more recent cases tend to indicate that bad faith might need to be shown, but that's not a clear delineation at this point. So if you want to get an adverse inference instruction, what do? And I've seen this arise a couple of different ways. In some instances, the party will ask for an adverse inference instruction, ask for a hearing before the trial even begins. We'll have a hearing, put on evidence, and the court will make a ruling, either at the time of the end of that evidence or say that we'll reserve ruling on whether the adverse inference instruction is going to be given until the trial has been completed. And I've done it both ways. I've had instances where there was a sufficient showing of bad faith that I could rule right then that they were entitled to the adverse inference instruction. I've had other instances where I was not yet certain whether they could meet a showing of bad faith, and reserved ruling. By the end of all of the evidence during trial, I concluded that they had made a showing of bad faith, and then gave the adverse inference instruction. I have also had cases where they didn't make a motion beforehand, put on the evidence during the trial, and I gave the adverse inference instruction at the end of trial. So it can be done in any of those three manners. The one thing I wanted to remind you, though, is that even if the court says that you're going to get an adverse inference instruction, you have to put on evidence during trial of what that intentional destruction was so that the jury understands why that adverse inference instruction is there and what conclusion they should draw from that evidence. There is no Eighth Circuit pattern jury instruction dealing with adverse inference. There are some cases that have reference instructions given in other district courts within the Eighth Circuit, but there is no Eighth Circuit pattern instruction. There is a South Dakota pattern instruction, and it's at 1:30, 1:20. And as you can see within that pattern instruction, it tells the jury that they have to decide if the evidence was intentionally destroyed and if it was destroyed in bad faith. And if so, they can make certain inferences. And that's why it's important that you put on that evidence during trial, because otherwise the jury doesn't have any ability to figure out if it was intentionally done or if it was done in bad faith. The next part of that instruction then indicates that the spoliator can rebut that evidence, and it talks about they have to put on a showing that it was done in good faith and it wasn't for the purpose of suppressing unfavorable evidence. And then the jury will just follow the instruction and do whatever they do back there in the jury room. But I just wanted to make sure that you understand how important it is that you put on the evidence of bad faith and intentional destruction, because otherwise the jury won't give you any inference. So I wanted to talk for a couple of minutes about a couple of cases and have you start thinking about whether you think somebody would be entitled to an adverse inference or some other type of sanction. There was a case issued by the 8th Circuit called Morris versus Union Pacific. And an accident happened when a Union Pacific train was coming through the small town of Waldo, Arkansas, and it collided with a tractor-trailer truck. And the local sheriff came, reported to the accident, and called out a local wrecking company to come and help remove the train and the truck from the streets. The wrecking company, the man that came from there was Mr. Morris. And he showed up and he started looking around the location of the train and the truck, made his inspection, tried to figure out how to move different things. And as he was looking between the train and the truck, all of a sudden the train lurched forward. And he ended up getting pinched between the train and the truck and had very severe injuries as a result. As you can imagine,